Welcome to Mayor Brown's Global Financial Markets Podcast. Each 30-minute episode is designed to help listeners better understand the legal issues that impact their business given the ongoing uncertainties in the financial markets worldwide. Speakers from across Mayor Brown's practices and offices provide their timely insights on a wide range of topics, including finance, financial services, and insurance regulatory developments, securitizations, and litigation in the United States, the United Kingdom, Europe, and Asia. We hope you enjoy the program.
Hello, listeners. Our topic today is the Corporate Transparency Act. My name is Gina Parlovecchio, a partner in Mayor Brown's New York office and co-chair of the Global Investigations and White Collar Defense Practice Group. Joining me today is Matt Bisanz, a partner in Mayor Brown's Washington, D.C. office and a member of the Financial Services Practice. With that said, let's begin. Matt, for those listeners who took the holiday off, can you tell us what happened in December with the CTA?
Well, Gina, as you know, the Corporate Transparency Act had a huge January 1st, 2025 deadline for the more than 30 million pre-existing companies who were formed before the January 1st, 2024 date. So we were quite busy before the holiday season getting people ready to file, assessing. But then on December 3rd, we had a quite a generous gift given that a court in Texas put in place a preliminary injunction that suspended enforcement of the CTA on a nationwide basis against all 30 million reporting companies. And it was premised on a request from a Texas business and a trade association who had filed a lawsuit saying that the CTA was unconstitutional for various reasons, including that the CTA exceeds Congress's power under the Commerce Clause and the Necessary and Proper Clause of the Constitution. So, in many ways, similar to the arguments that were brought against the Affordable Care Act several years ago. The court found that at least at the preliminary injunction stage, those were persuasive arguments, and given the impending January 1st deadline, the court suspended enforcement universally. That was confirmed by FinCEN, the agency who enforces the CTA. They said, yes, we will respect the court's opinion. No one must file. But FinCEN then made an emergency appeal to the U.S. Court of Appeals for the Fifth Circuit, which is the appellate court that hears these kinds of matters. And FinCEN said, look, there's really no reason this should be a nationwide injunction. Courts, there's a preference to not bring them. Please put back in place this January 1st deadline. And I think you're going to talk more about it in a minute, but the way things work at an appellate court is there's kind of like the duty clerk, the judge who is sitting receiving these emergency requests, and they call that, I guess, the motions panel. And so this motions panel received FinCEN's emergency appeal, and they said on December 23rd, oh, yes, we see your point. There is really no reason to grant a preliminary injunction. We're going to reinstate the CTA's as a pending resolution by the lower court. And FinCEN gave a brief extension, I think, until a few weeks. But FinCEN said, okay, game's back on, let's file. I then proceeded to tell all our clients that and go on my Christmas cruise on Disney to the Bahamas. And as we're touring through Nassau, I get an email on the December 26th saying, oh, wait, the part of the Fifth Circuit that actually hears the substance of these appeals, they now read more closely, and they are actually vacating the order that was issued on December 23rd. And so this new part, the merits panel of the Fifth Circuit, is resuspending all of the CTA obligations until they issue a final decision. So that was great news, and it was gave our clients relief through the end of the year. And so now the Fifth Circuit merits panel will hear things on a going forward basis. But at least I didn't know about the merits panel or the motions panel before this. And maybe since you're a litigator, can you talk about the procedural posture from this kind of appeal?
Sure. Actually, coincidentally, I clerked on the Fifth Circuit many, many moons ago, so I can talk to this issue. So basically, it's one thing that I would say is unusual is it's unusual in any instance for an appellate court to reverse itself within the span of 3 days. But as you've already previewed, Matt, there is a reason for that. So what essentially happened here was that the motions panel of the Fifth Circuit heard the government's motion to stay. And as you mentioned, the motions panel, it's a panel of 3 judges who are essentially on duty to hear emergency motions of this nature. And of course, as we know, they stayed the Texas District Court's order finding the Corporate Transparency Act unconstitutional and unenforceable. But in doing so, the motions panel had to consider several factors in determining whether a stay of the district court's order was warranted. And interestingly, one of the things that Fifth Circuit motions panel found was that the government was likely to succeed on the merits in showing that the Corporate Transparency Act is a constitutional exercise of Congress's Commerce Clause authority. And the motions panel also found that irreparable harm could result from the district court's order because a last minute measure to block a lawfully passed legislation of this nature is considered under the case law a form of irreparable harm. And so the motions panel found that there was an interest in protecting against the financial crime, which of course we know the Corporate Transparency Act is designed to do. So of course, as we know, the merits panel gets assigned, which is a different panel, and it's sort of sent to the wheel, as they say. And so three different judges are assigned. And the merits panel issued an order stating that the merits panel will ultimately decide the appeal on its merits after having the opportunity to give more attention and time to analyzing the merits of the district court's reasoning and the parties' arguments. So the merits panel now has the appeal, which is expedited. And the panel then stated, in order to preserve the constitutional status quo, while the merits panel considers the parties' more substantive arguments, it was going to vacate the motion panel's order, staying the district court's order. So once again, putting everyone back at square one under the district court's order. And to use your terminology, Matt, it's game off for filing under the beneficial ownership registry. So, Matt, that took us through the end of the year and the setting of arguments at the Fifth Circuit. Is that the end of the story until March 25th?
Unfortunately, no. I wish it was in some ways, but the FinCEN quickly appealed the Fifth Circuit decision to the U.S. Supreme Court. It goes first to, they call it the Circuit Justice or Justice Alito, and he could have resolved it on his own. That's quite uncommon to do. And so instead he asked both sides for arguments and brought it to the full Supreme Court. There was no oral arguments in an emergency preliminary setting like this. It's just done based on the papers, which surprisingly there were over a dozen amicus briefs filed in that very short time. He only gave them, I think, like 7 days or so to make their filings. And then on January 23rd, the Supreme Court issued a very brief order suspending the stay that the Fifth Circuit had put in place. So kind of undoing what that merits panel had done, saying, well, look, in this case, there is a stronger interest in the government being able to enforce the law. The lower plaintiffs haven't shown the kind of irreparable harm that you alluded to. We don't know what the specific vote was. We know that at least one justice dissented, that Justice Jackson would have kept the stay in place. Justice Gorsuch wrote separately to saying, look, I think this would be a great case for us to decide whether nationwide injunctions ever are appropriate. But I think we can at least infer there were at least 5 justices who felt it should go back into effect. And we had clients who were quite worried at this point of, oh man, if the Supreme Court puts it back into effect, does that mean I have to make a filing that day? What would happen? Um, and we were concerned. I even do our firm's filing obligations, and I wanted to make sure we had it all ready to go because I didn't know what kind of leeway the Supreme Court would give us. And also it's kind of looking at the politics of it as well, that this goes back to eventually now the Texas District Court to look at the issue on the merits. There are the substance of the Commerce Clause and Necessary and Proper Clause. There's also arguments relating to the Fourth and Fifth Amendments, and so this could really have the potential to ping back and forth. That you could go back to the lower court, and the lower court says, okay, well, yeah, there wasn't preliminary injunction grounds for the Commerce Clause. Like the Supreme Court now tells me that, but I think there's preliminary injunction under the Fourth Amendment or the Fifth Amendment. And so that was what I think a lot of us were afraid was going to happen. And so even though the Supreme Court usually would be the final say on whether this goes into effect, it wasn't the case here. There's actually another Texas case that maybe you're going to tell us a little more about, called Smith, that really muddied up that whole basic order that we were taught in law school.
That's right. So, as you mentioned, on January 23rd, the Supreme Court lifts the injunction on the enforcement of the Corporate Transparency Act that had been put in place by the district court. And the case we've all been talking about, which is also known as the Top Cop Shop case, the Texas Top Cop Shop case, which is hard to say 10 times fast. However, in the intervening period between the government defendant's emergency application to the Supreme Court in the Texas Cop Shop case and the court's January 23rd, 2025 decision lifting the injunction, that same Texas District Court issued a separate injunction in connection with a case that is known as the Smith case, which ultimately stayed the Corporate Transparency Act's reporting requirement. So, the Supreme Court's January 23rd order does not address the separate stay that was a result of the Smith case. And basically what that stayed was the effective date of the reporting rule that in the Smith case. So notwithstanding the Supreme Court's order, the obligation to file beneficial ownership information remains suspended. And in fact, just recognizing that, this sort of unusual reality, on January 24th, FinCEN issued a notice confirming that it plans to comply with the second injunction from the Smith case coming out of Texas. So, as a result, for the time being, the reporting obligations under the Corporate Transparency Act do remain suspended. But FinCEN will continue to accept beneficial ownership reports on a voluntary basis, of course. So, just going back to the sort of unusual posture that this is in, while the Supreme Court's order removed one of the remaining hurdles to the reporting rule becoming effective, it's not entirely clear when the beneficial ownership filing requirements will take effect, as you've noted, Matt. But there's like a slight difference between the two Texas District Court injunctions. Unlike the original injunction, the second injunction in the Smith case enjoined enforcement of the Corporate Transparency Act only against the parties in the case, but the district court stayed the effective date, that January 1st date of the reporting rule nationwide. So that's just, a slight difference, but it just creates this ambiguity, which makes, the need to suspend reporting requirements indefinite until there's more clarity. So, Matt, what are some other factors that might influence where the Corporate Transparency Act goes from here?
Well, that's a good question, because one thing I thought when I heard this is what even with that distinction that you drew in how the Smith case had a slightly different scope than Texas Top Cop Shop. like what lower court judge really is going to want to be on the wrong side of the Supreme Court? That while the Supreme Court didn't expressly vacate Smith, like they kind of made a clear point to here, and so I thought, like, well, like, how does this work? And as I learned, it's not automatic. Like Smith is no longer good law, but it still stands until the stay is vacated. Um, and so I thought, well, will the judge do it on their own? And I mean, he obviously can, but typically it would be that FinCEN, or the DOJ on FinCEN's behalf, would make a motion for him to vacate it in light of the Supreme Court ruling in the other case. That request has not been made yet. And one of the things that happened between December 26th and January 23rd is we have a new presidential administration. And there have been in the press numerous personnel changes, and we have a new Secretary of the Treasury. He will almost certainly appoint a new head of terrorist financing as the Assistant Secretary for TFI. We have a new Attorney General she will almost certainly be appointing new U.S. attorneys for with the president for Texas, and so it is conceivable that if the new administration decides to either not defend the CTA or not defend the pause of, or not defend putting it back into place while the case goes on, they could just leave the Smith injunction in effect and let things proceed. And so we are still looking every day at Pacer. We have our little alerts to let us know if DOJ makes a request to vacate the Smith stay. But it is this kind of odd situation where through inaction, the industry might get the very thing it was denied through so much action. I'm also expecting there will be some other litigations filed in amicus briefs, and certainly when Texas Top Cop Shop gets back down to the Texas District Court, there will be many amicus briefs from the very interested parties now in the substance of that. So I dare say that the CTA might become a full employment act for litigators like yourself, especially amicus brief writers like our huge Supreme Court practice here in DC. So congratulations to you guys.
Thank you very much. So thank you, Matt, for joining me for this episode. And thank you to our audience for listening. Listeners, if you have any questions about today's podcast or anything else related to the global financial markets, please email us at gfm@mayorbrown.com.
We hope you enjoyed this program. You can subscribe on all major podcasting platforms. To learn about other Mayor Brown audio programming, visit mayorbrown.com/podcasts. Thanks for listening.